Hello, my name is Dr. Chuck Stowe, and I'd like to welcome you to VA 251 Summer 2014. This intro PowerPoint covers Chapter 1, but it also explains a little bit about some of the dilemmas I face in putting this course together for you. Why do I have publishers, why don't I use publishers' PowerPoints? Because frankly, they're just a copy of what's on the page in your text. What they're trying to do is cram down a lot of vocabulary to memorize in kind of a high schoolish way. This is a college course, and in the real world, I'm trying to prepare you for what we need to do is to be aware of legal issues, to understand some legal concepts. You can get to Google, you can get to the internet, you can get to places that can give you the right answers, or at least guidance in finding the right answers. The problem is that we have to be able to make decisions, and all decisions have legal implications. Now, lawyers are expensive, and the typical faculty member says, well, why bother with law? It's not that important. Well, I'll tell you why it's important. You're going to pay $5 a minute to get legal advice. That's what it costs now. And so you need to know, as a business person, where to look and how to kind of think like a lawyer so that you can make proper business decisions without going broke having to hire a lawyer for everything. Now, our problem this summer is that I don't have lectures, and so you're not going to get an opportunity really to practice taking notes. You'll notice that I left some PowerPoints up on note-taking, but all I can really cover with you and test you on, because of the nature of the course, is on time management, our first assignment, which many of you have already completed. But I don't want to cheat you out of what's available to other classes, so I've left open some other videos that we're not going to test you on, but are there if you have time to look at them. Now, the second problem we have is that one class day in summer school equals 1 week of normal school. So you're going to have to devote 2 to 3 hours at least per day to keep up with what we have to do in this course. I'm sorry about that, but that's the way this thing is laid out time-wise. So it is a challenge for both of us. The reason for my video PowerPoints is that, and the other PowerPoints I have, is to try to focus you on the complex or confusing issues. I've tried to tie these PowerPoints to questions on the quizzes or on the exams. And I'm trying to present some concepts that the book leaves out. And that's certainly what I've done in this first one. There's a concept called American exceptionalism. And it's missing in the textbook, but it is absolutely critical and is not well understood by the major media. You know, in human history, all prior governments were based on people worshiping their rulers. In some societies, they consider their rulers to be demigods or human beings, but endowed with godlike powers. And so people in Egypt or Mesopotamia, which is the old Persia or now Iran, the Roman Empire, people worshipped Caesar. You can remember that if you happen to be into the Bible. You can remember that from the Bible. The Christian influence, however, on our founding fathers was very different. The Puritans and others who became our founding fathers believed that government serves people. Why? Because their view was that God created everyone with inalienable rights, and that leaders are no different than other human beings. Radical thought. Remember, even monarchies, where you had kings and queens, people were called subjects, meaning they were subject to the whims of the king or the queen, the top person in government. The American Revolution was a very radical revolution. For the first time in human history, people said, no, no, rulers are not our kings. They're not our gods. There is one God, and he gave us inalienable rights. We are all equal under the Lord. We're all, quote, God's children. Those of you who are Christian, you've heard this before. So when the founding fathers rebelled from the king and the queen, they designed a government through a constitution that provided for checks and balances. For what purpose? To limit the power and authority of the central government. Now, recent events, some people feel differently. They want a bigger government to take care of more of your problems, more of society's problems. And so there is this tension in the current American political system between those who want much more limited government and those who are advocating a very strong, very powerful central government that will provide for our protection, but on the other hand, give the government the right to look at all our emails, to listen to our phone calls, and so on. So this is, I'm not taking sides, I'm just pointing out, when people talk about American exceptionalism, the lawyers, the scholars, they're talking about a very different philosophy between people and their governments. One where the original founding father types, not all of them, but most of them were Christian types who believed in this concept that God gave all of us children the same rights. Okay, the other concept it's covered in chapter 1, but I just want to hammer this to you. Common law is the total result of all published legal opinions by appellate courts that rule on what are called questions of law. Now, it's important to understand the difference. Questions of fact is what the jury is supposed to determine. Questions of fact comes about because did the defendant walk in the store, pull a gun out, and ask for money? Yes or no? Is that the right defendant? Yes or no? Those are questions of fact. Now, they're based, the jury makes their decision based on the likability and credibility of the testimony. Let's face it, that's all they've got. Who do they believe? Who has the motive to lie? Who is most likely telling the truth? Now, on the other hand, questions of law are very different. Questions of law involve what we call procedural questions, which is simply asking, did the court follow the right rules in conducting the trial? That's procedure. On the other side, there's called substantive questions of law. Did the trial court properly interpret the law or apply the law to this set of facts? Now, which set of facts do they use? The plaintiff or the defendant? This is where the jury comes in. An appellate court will always use the facts that support the jury's verdict. So whatever the jury decided, that set of facts, if they found the defendant guilty, for example, then they're accepting the plaintiff's set of facts. Okay? Now, these appellate courts get what's called a legal brief, which is a list of questions of law that the losing party wants the appellate court to reverse the decision of the trial court. And so they write everything they can think of that might have been wrong, either procedurally or substantively, with the way the trial court conducted and ruled on questions of law. When the appellate court is done with making their decisions, they publish them in what's called a legal opinion. Common law is the entire published history of those appellate opinions. Now, the opposite of that is called statutory law. That's where Congress or a state legislature pass a law, and that law is what is followed. That's called statutory law. So common law is judge-made law from appellate courts, ruling on questions of law that came up that the loser is saying, hey, something's wrong here. I should have won and I didn't, and here's why, on the basis of questions of law. Not on questions of fact. You get one jury trial, that's it. Now, the third concept is embedded in the first 3 chapters, but it's not, you're not going to find it. Here's the lesson for you. Lawyers read faster than you can talk. So if you're dealing with a lawyer for advice, you bring all your documents. But before you do that, make a chronological list of what you think happened. Chronological meaning in the order of time. What's happened first, second, third, fourth. Now, law is, the lawyer is going to want to know, what do you think the opponent's strongest arguments or facts are that they will use against you? So make a list of those, okay? Now, law is a process, not a result. So when people say, how much is this going to cost for this result, the lawyers are going to refuse to answer that. So instead, ask, how much do you charge for a demand letter? That's the first thing when you're suing someone. How much do you charge for your time in negotiating a settlement? How much do you think we will probably spend in discovery? How long a trial do you think this might be, this particular dispute? What do you think it would cost to appeal the results of the trial? Now, you're asking a lawyer not to predict or guarantee results, but to give you an estimate of time, which you'll multiply times their hourly rate. And their hourly rate will be around $300 an hour, which, shockingly, amounts to about $5 a minute. So law is very expensive. Now, in addition to that, you're going to pay for telephone calls and court expenses. You'll also pay for any costs of investigating or hiring experts to help determine the cause of your accident, for example. And all of that is going to equal your estimated legal fees. And you as a business person must determine, is it worth the price? And remember, lawyers never guarantee a result, which is very different from business people that must produce results to get paid.